Hello, my name is John Pinkowski, and welcome to a live CLE on Florida guardianship matters. Today we're going to be discussing verified statements in guardianship proceedings, what Florida probate and elder law attorneys need to know about Chapter 744.331 and the Searle v. Bent case. If you're an estate planning lawyer in Florida, or you have an elder law practice, or you're a probate lawyer in Florida, the following hour will earn you 1 credit with the Florida Bar for general credit hours. And this will be an informative topic on verified statements and Florida guardianship law. So with that said, let me give you a broad overview and then we'll go into the matters that we're going to be discussing today. My name is John Pinkowski. I'm a probate litigation attorney with Pinkowski Hauser in downtown West Palm Beach, Florida. Our firm limits its practice to trials, disputes, and appeals only regarding probate, estate, trust, guardianship, and related commercial and real estate litigation. The sponsor of today's live CLE webinar is my firm, Pinkowski Hauser, and we're on the web at phflorida.com. I invite you to listen to our other webinars and CLEs that are available for the general public as well as Florida attorneys. And if you're a Florida attorney out there, we had some live CLEs, continuing legal education courses, for which you can get credit from the Florida Bar on ethics, estate planning malpractice, probate malpractice, and charging liens. The purpose of our live webinars and our live CLEs for Florida probate lawyers is to advise the probate lawyer or the estate planning attorney or the lawyer who has an elder law practice on our perspective of cutting edge issues, recent cases, and recent legal developments in the areas of wills, trusts, estates, probate, and guardianship matters. So for the next 50 to 60 minutes, we're going to be discussing Florida Statute 744.331, 6F, the statute on verified statements. And we're going to ask ourselves whether a recent case from a few years ago, the Searle v. Bent case, poses some risk of abuse, poses some risk to your Florida guardianship practice, and whether your clients can be adversely affected by a baseless verified statement, and how you handle that. So why are we here today? Well, I hope to give you perspective, right? Our practice is a litigation practice. We're probate litigators. And although our office is in West Palm Beach, Florida, our practice is throughout the Sunshine State, throughout Florida. And I hope to give you some insight, some feelings, some thoughts, some perspective from what we see at our law firm, our small group of litigators and paralegals. What do we see out there in the trenches when we are litigating guardianships, or what we call contested guardianships, when we're involved in contested guardianships, when we're in court at evidentiary hearings and trials, when we're handling appeals? What are the issues that we see? What are some of our reactions to recent cases and statutes, as well as new legislative, new laws and new legislative action and new statutes? So some perspective from trial attorneys to elder law, probate, and estate planning attorneys, or sometimes you can refer to this as what gives us heartburn. So today we're going to be discussing 7 topics. We're going to start with an introduction. We're going to talk generally about lesser restrictive alternatives to a guardianship. And today we're going to be speaking about guardianship for adults, right, for mom or dad. We're not going to be speaking about guardians ad litem. We're not going to be speaking about guardianships for minor children in Florida. We're talking about those people who in their sunshine years may be afflicted by Alzheimer's or dementia, or they may require a little assistance and maybe some protection, and maybe they are partially or totally incapacitated to such a degree that a judge is going to remove some of a person's rights, right? And grant those rights, take away those rights and give them to somebody else, a guardian, maybe, maybe not. Might be that your power of attorney, your attorney in fact, or your trustee of your revocable trust will do just fine and you don't need a guardian. We'll discuss a little bit of that today. We're going to discuss legal duties and obligations, and we're going to talk, interestingly enough, about the duties of a court in a guardianship proceeding. And we're specifically going to be speaking about two recent cases that address that issue. We're going to go over rules regulating the Florida bar. And when we talk about duties and obligations and rules regulating the Florida bar, we're going to discuss the second Saadeh case, where the 4th District Court of Appeal discussed that the attorney for an emergency temporary guardian owes a duty to the ward, to the alleged incapacitated person, right? And in Florida guardianship law, we use those two titles to mean different things, but often they refer to the same person. Somebody who is accused of or alleged to be incapacitated in needing of assistance, needing of protection, is referred to as an alleged incapacitated person or an AIP. If a probate court judge in Florida makes a finding of incapacity, we then often refer to that individual as a ward. After discussing legal duties and rules regulating the Florida bar, our ethics rules, we're going to talk a little bit more about verified statements and guardianship proceedings. We're going to speak about specific statute throughout today's live CLE. Then we're going to speak specifically about the Searle v. Bent case, right? A 2-year appeal, and I think it's a 31-page order that the trial judge, that the probate court judge entered. And then we're going to conclude. Okay, so that is kind of our background to today's CLE on Florida guardianship law. Let's get into the introduction. What are we talking about here today? Well, we're talking about, as I hinted, incapacitated adults. We're not talking about minors. And, you know, when we talk about a guardianship proceeding, we're generally speaking about two components. There's the incapacity component, where a court is going to make a determination about whether somebody is incapacitated or not, and whether that incapacity is partial or whole, whether a plenary guardianship is required. Right, somebody can be in need of a little assistance, right? Somebody might not be able to exercise all their rights, right? They're not competent enough, or they don't have enough capacity to maybe contract or buy and sell things or pay their own bills or file their own taxes. But they can determine where they want to live or who they socialize with. Maybe they don't have the ability to drive, so maybe those rights are taken away. And the second component, of course, is the guardian. Is a guardian going to be appointed, and if so, who should that be? So what is a guardianship? Well, a guardianship is a legal proceeding in the circuit courts of Florida, which have exclusive jurisdiction over guardianship matters. You're not in the county court, you're in the circuit court. Typically, you're in the probate division, that division which handles estates, wills, trusts, probates, and all trust matters. And it's a legal proceeding in which a guardian is appointed to exercise the legal rights of an incapacitated person. We know under the Florida guardianship statute, specifically 744.331 subparagraph or subsection 4, that if the examining committee members who go out and interview and write a report about the alleged incapacitated person, if a majority of those examining committee members conclude that the AIP, the alleged incapacitated person, is not incapacitated, the court shall dismiss the petition. So that's very important, right? Because once a guardianship matter is filed, all these things start to happen. There's a flurry of activity. The court will typically appoint a lawyer to look out for and protect and meet with the alleged incapacitated person, and only the alleged incapacitated person. And the court often wants to hear from that lawyer. What does the lawyer think? And what's the lawyer arguing or advocating for? An examining committee is appointed, where typically 3 individuals, one of whom may be a medical doctor, the others may not be, will be appointed to go out and examine the alleged incapacitated person. They meet with this person, they ask them questions, and they file a report. and that report is read by the judge, and oftentimes it's entered into evidence, or those examining committee members come and testify as to whether this person is incapacitated, to what degree, and whether any rights should be removed, and if so, what are those rights that should be removed from this alleged incapacitated person. Right? If you're incapacitated, you're incapable of exercising at least some of your rights, maybe all of your rights, and the examining committee members are going to make a recommendation to the court on what rights should be removed from this alleged incapacitated person. What rights is this judge going to take away from this person and give to somebody else? In addition to that, a hearing is typically scheduled where there is a hearing on determining whether the alleged incapacitated person is incapacitated or not, and oftentimes at that hearing, what we call an adjudicatory hearing, you can look at 744.331 in the Guardianship Code for that. That's subparagraph 5. The court's going to set a date for both those matters, the petition to determine incapacity and the petition for appointment of a guardian. And subparagraph 5 of 744.331 talks about timeframes and the importance of doing this rather quickly, because we're talking about a person's civil liberties, civil rights, and human rights. And it's something the courts take very, very seriously, but also because we don't want those examining committee reports to get stale, right? So you'll see a 14-day time frame in that statute where the court should have the hearing on incapacity 14 days after the filing of the reports of the examining committee. So you have those two components. There's typically a petition to determine incapacity that's filed. You can look at 744.3201 in Florida's Guardianship Code. And then the second petition is typically a petition for appointment of a guardian, right? And that's generally the case. Although sometimes you have the issue of, I want a determination that the person is incapacitated, but I don't need a guardian because I've got a power of attorney, and that power of attorney or attorney in fact can make determinations and make decisions and protect this person. Or there's a trustee of irrevocable trust, and they can manage the property once the ward's property is transferred to the trustee, and they can manage the property and account. And there's healthcare documents too, right? And if those healthcare documents are valid, you have all this stuff, you don't need a guardian, right? You can have those people exercise the ward's rights. So by way of background, you know, there's 56 trillion reasons why we're here today. $56 trillion is the amount of money that the Boston College Center on Wealth and Philanthropy has estimated has passed, is passing, and will pass over the next decade or two from the World War II generation to descendants, such as the millennials, Generation X, Gen Y, and certainly the baby boomers who are now in their 60s and 70s. The greatest transfer of wealth in humankind. Now, most recently, in January or February of 2017, RBC, the Royal Bank of Canada, issued a study on wealth and inheritance. They interviewed a number of people with an average net worth of over $4 million. And the purpose of the study was, and the survey was to see what people were thinking about leaving wealth, inheriting wealth, and whether they were transferring not just money and wealth and assets, but also skills or an understanding to deal with that wealth. They estimated that the transfer of wealth that's going on right now is considerably less. I think they estimated it was about $3 or $4 trillion. But you can see there's literally trillions of dollars at stake. And for good or for ill, people are going to the probate courts to exercise their rights and be heard. And probate litigation is increasingly more common. So as far as legal trends that we see at P.L.L.C. Hauser, I mean, we're seeing estate planning lawyers, our friends who have an elder law practice in Florida, what you might call a Florida probate practice. They now have guardianship practices, or guardianship work as a component of their practice. And now litigation is a little bit part of their practice. Why? Because when you go to court in these guardianship matters, they call them adjudicatory hearings and evidentiary hearings, and those are, you know, pseudonyms for trials. And so you need to know trial practice, right? You need to have trial practice skills. You need to know the rules of evidence, the rules of civil procedure. You need to know how to call witnesses, how to introduce documents, how to impeach witnesses, how to object. You need to know the exclusionary principles of evidence, how to keep things from coming into evidence when the admission of them would not be proper. So as we said, guardianship litigation seems to be exploding. As we age, the likelihood that as we're living longer, the likelihood that we'll need some help has never been greater, whether we suffer from Alzheimer's or dementia. As we age, our bodies, our physical beings may be fine, but our minds can decrease and diminish to the point where we're susceptible to the advances of others. And we really can't care completely for ourselves, not 100%. And that's where probate litigation law firms in Florida come in, right? You often have sibling rivalry vying for control over the person and purse of mom or dad. We see it increasingly in second and third marriages where the latest spouse is warring with adult children from a prior relationship, right? So you're seeing all of that, a lot of fighting, a lot of sibling rivalry. You know, it used to be that the old way of doing business was that people didn't fight over money and mom and dad until they passed away. And so they'd be fighting in the limo on the way to the funeral or coming back or shortly thereafter. Now, as mom and dad age, they're vying for control through a guardianship proceeding. Let's talk about a lesser restrictive alternative to a guardianship and what that means. Many of my colleagues out there who are Florida estate lawyers know that I published a book called P.L.L.C's Trustee's Guide that provided insight into what a beneficiary can expect from their trustee and how a trustee can be a good trustee and also how a trustee can be a bad trustee. Please look for my latest books coming out on probate litigation and guardianship law that should be available in 2017. And in Florida, you know, we see a lot of times allegations of financial exploitation, right? We see examples of deeds that are signed by a power of attorney, you know, an attorney in fact for his or her own benefit. We see names placed on bank accounts. We see transfers of assets like money, cash, financial accounts to others. And so many times those financial wars are fought in a guardianship proceeding. And so Florida Statute 744.331, very, very important guardianship law or statute regarding incapacity. It's almost a legal roadmap telling the parties and the court just about everything you need to know surrounding a finding of incapacity or at least allegations of incapacity. So Florida's guardianship code is Chapter 744. You can read it in less than an hour, but 744.331 Florida laws on guardianship, very, very important that every guardianship lawyer seems to know. And so the verified statement statute is found in that guardianship code section, 744.331 6B, paragraph 6, B as in boy. And what it says is when an order determines that a person is incapable of exercising delegable rights, the court must consider and find whether there's an alternative to a guardianship. Is there something else, something without court supervision, maybe something that's less invasive and less costly to a guardianship that will sufficiently address the problems of the incapacitated person? It's not enough that these alternatives to a guardianship address the problems or the challenges of the ward or the AIP. They have to sufficiently address the problems. And when we see words like sufficiently, probate litigation lawyers in Florida know that, you know, a court's going to make a finding of fact. and courts only make findings of fact based on evidence. And you're going to hear me talk a little bit about later about trying these cases and being prepared with your evidence, being prepared with documents and testimony, and making sure you get it right. Now, a guardian may not be appointed if the court finds that there is an alternative to a guardianship, which also sufficiently addresses the problems of the ward. So first, the court has to find that there's an alternative to a guardianship. And then secondly, the court has to find that it sufficiently addresses the problems of the incapacitated person. So we're going to see in a little while that, you know, someone's estate plan can be a very viable, very good alternative to a guardianship that sufficiently addresses the problems of the ward or the alleged incapacitated person. The challenge comes in with verified statements. And the question that we're asking today, or one of the questions is, can the verified statement statute in Florida, can a guardianship verified statement filed in Florida, an affidavit, bring one's estate plan to a screeching halt? Can it change the course and direction of a guardianship proceeding? And can it, in essence, nullify to some degree or ignore someone's estate plan? The answers to those questions is yes, that can happen. We're going to discuss that today, and we're going to consider whether people will be abusing these verified statements to try to throw a monkey wrench in someone's existing estate plan. Because remember, a lot of estate planning attorneys, a lot of probate lawyers prepare basic estate plans for clients every day in Florida. And those aren't just wills. You often have a will, you have a revocable trust, a power of attorney, and healthcare documents, right? And these are documents, if they're valid, where the person, the client, is making choices about who she or he wants to make decisions for them, manage their property, and conduct business for them. And so the thinking is, look, if you have a valid estate plan, you don't need a guardianship as long as the estate plan sufficiently addresses the problems of this person who is now incapacitated. Why? Because if you have a valid estate plan, the ward, the alleged incapacitated person, already made these decisions when he or she was competent, right? They chose the person to manage their property if they were incapacitated. That's the trustee of your revocable trust. They chose the person to take actions for the client. That's your attorney in fact or power of attorney, right? So if you have property that's not in the revocable trust and you're incapacitated, not to worry if you have a valid POA. The Florida power of attorney will gather your assets, put it in the trust, convey it to the trust. Your trustee who you chose will manage that property. In addition to that, we know that many times estate planning lawyers prepare healthcare documents for a client, where these healthcare documents might select who your guardian is, might select who your alternative guardian is, you might have a living will that declares what your intent is regarding whether or not you want to be sustained by artificial means if you're in a persistent vegetative state, right? You might have healthcare documents that actually empowers somebody, like under an advanced healthcare directive, or what some people call a medical durable power of attorney, or what in Massachusetts they call a healthcare proxy, where you empower somebody to make medical decisions for you. Well, if you've got somebody to make business decisions for you, if you've got someone to manage, protect, look out, and account for all your property, and you've got someone to make medical and health decisions for you, do you really need a guardian? And the answer is probably not. But that can all be set aside and at least delayed if a verified statement comes into play. And that's what causes heartburn among some probate litigators. So let's consider what is an alternative to a guardianship which might sufficiently address the problems of the ward, power of attorney. We mentioned, you can read Chapter 709. In 2011, the Florida legislature completely wrote our Florida Power of Attorney Act. You can read all about that now. And if you're interested in language or a reference to a durable power of attorney, you can see Florida Statute 709.2104. That's a law in the Florida Power of Attorney Act it talks about a durable power of attorney, right? A power of attorney that's just a regular power of attorney terminates with death or incapacity. A durable power of attorney terminates with death, but it doesn't terminate when the principal of the person who created the power of attorney becomes incapacitated. It specifically permits the attorney in fact, your power of attorney, to take actions for you, the principal, the client, the creator of the power of attorney, during your incapacity. Very, very important documents. In my book, P.L.L.C's Probate Litigation Guide, I refer to a power of attorney as one of the most dangerous documents in the world. Why? Because it's subject to misuse, right? It's such a powerful document. Even though the law prohibits self-dealing and conflicts of interest, we see many times, for good or for ill, people with powers of attorney transferring assets, and many times for ill, doing bad things with powers of attorney. Now, understand that under certain circumstances, a power of attorney, even if it's valid on its face, may be suspended. May be suspended by an allegation, a filing, and certainly by an order of a guardianship court. You can read Florida Guardianship Law 744.3203 a little bit more on that. Healthcare documents we discussed. You see that Florida Law 744.3115 speaks about advanced directives for healthcare. Okay, let's start discussing a few cases, and we're going to get into our third legal topic, which is legal duties and obligations. Does the probate court judge, does the Florida guardianship judge have a duty? Well, two recent cases said yes. The court actually has a duty. It must appoint a guardian to protect the ward if there is an incapacity. If the ward is in need of protection, if the ward is in need of some assistance, if the ward is not capable of exercising all of his or her rights. You can read the Saadeh case from 2012. There's two Saadeh cases out there. This is the 2012 case. Jasser v. Saadeh, Jasser v. Saadeh, S as in Sam, AAD as in dog, EH, 97 Southern 3rd, 241, a Florida 4th District Court of Appeal opinion from 2012. That's different than the Saadeh v. Connors case, which we're going to discuss later. More recently, on January 10th, 2017, Florida's 1st District Court of Appeal cited the Jasser v. Saadeh case in the Cason v. Ross matter. Cason, C-A-S-O-N, v. Ross, R-O-S-S. The Westlaw site is 2007 Westlaw 90483, decided on January 10th, 2017, Florida's 1st District Court of Appeal. You can actually get a copy of that opinion by going to Florida's 1st District Court of Appeal website and looking in their archived opinions. And in the Cason case, there was an issue about obtaining a writ of mandamus through the appellate process. It was the appeal of a guardianship order in Florida. And the court cited the Jasser v. Saadeh case and said that, yes, if a person is incompetent, it is the duty of the court to assure that the person's protection and his or her autonomy is respected to the greatest extent possible, and recognizes that a guardian should be appointed. Okay, in the Cason case, there was a clear finding of incapacity, but no guardian was appointed, and so the appellant sought a writ of mandamus to the appellate court and said, hey, I want you to compel the trial judge, the probate court judge, to appoint a guardian. The appellate court said, hold on. It appeared that the trial judge determined that he could not enter an order on the guardianship matter before his time in the division ended. I don't know any more about that. But the appellate court, the 1st District Court of Appeal in this guardianship appeal, went on to say, there's no showing that the petitioner made an express request that the trial court enter a new order that appointed a guardian. So you're reading this and you're scratching your head wondering, could we have avoided an appeal and the cost of a Florida guardianship appeal if we simply asked a new judge or a different judge, maybe even the same judge in the guardianship matter, if he or she could just enter an order appointing a new guardian. Okay. So what's the duty of attorneys in Florida? Well, you'll see the rules regulating the Florida bar are right up there. You've got lots of duties, all right? You need to be competent, right? You need to know the extent and scope of your representation. You don't want to take on too much if you're not competent. You don't want to do a bunch of stuff that isn't required or necessary to protect your client. You need to be diligent. You need to communicate. Your fees and costs need to be reasonable under the circumstances. You've got to keep everything confidential, and you're supposed to avoid conflicts of interest, okay? Why am I asking about conflicts of interest and rules regulating the Florida bar when I'm talking about duties of an attorney? And that's because of the Saadeh case from June 24th, 2015, right? Saadeh, S-A-A-D-E-H versus Connors, C-O-N-N-O-R-S, June 24th, 2015. The citation is 166 Southern 3rd, 959, Florida's 4th District Court of Appeal. Another guardianship appeal, June 24th, 2015, where the Florida's 4th District Court of Appeal said that the attorney for an emergency temporary guardian owes a duty to the ward, right? So in the world of malpractice, right, and I gave a live Florida CLE on malpractice in December of 2016. If you want to listen to that or you need ethics credits, email Amanda at phflorida.com, Amanda at phflorida.com. Her phone number is 561-514-0900, extension 101. Just call the firm, call P.L.L.C. Hauser, ask for Amanda, extension 101. She'll get you the free link to my live Florida CLE on malpractice. And we discussed the Saadeh case a little bit, and we discussed the duty that's owed by an attorney in Florida. And these live webinars are free. They're free of charge. They're sponsored by my firm P.L.L.C. Hauser. But in this Saadeh v. Connors case, right, this was kind of opening or extending the duty of a Florida lawyer. We know the Florida lawyer owes a duty, all the duties, to the emergency temporary guardian that he or she represents. But the 4th DCA went a little bit wider and said, you know what? The attorney for the emergency temporary guardian in incapacitation proceeding owes a duty to the ward, and talked all about how this whole guardianship proceeding, the guardianship code, the guardianship laws, this is intended to help one person and one person only, the AIP, the alleged incapacitated person, right, the ward, right? To tolerate anything less would be nonsensical, according to the 4th. It would strip the ward of the dignity to which the ward is wholly entitled. So, lawyers out there who represent guardians, be very, very careful. You need to understand and read Saadeh v. Connors. You need to recognize that you owe a duty not just to your guardian, but to the ward. And I think this comes up in the context of settlement agreements and attorney's fees. Why do I say that? You know, probate lawyers who don't litigate are often accused of playing lawyer, playing trial lawyer. They want to go into court, but they don't really know how to try a case. And they settle everything, right? If you ask any trial court judge, probate court judge, they will tell you that they have 1,600, 1,800 cases on an annual basis. And a minute fraction of them actually go to trial. And so, you know, probate lawyers are accused of settling everything, right? They don't want to go to trial. Let's just carve up the money. Whether that is justifiable or not, you can leave to another day. But if you're cutting a deal with the ward's money, you need to be mindful that if you represent the guardian, you also represent the ward. And so now you have two people to be careful about and cautious about. And particularly this comes up and causes great concern to our guardianship judges, and rightfully so, in Palm Beach County and Broward County, where if you go with a deal, a settlement for a contested guardianship, our judges want to know, are you giving any money of the wards away? Are you giving it to the parties? And are you trying to use the ward's money to pay attorney's fees for those other than the ward? Excellent questions. If you're an estate lawyer or a probate lawyer or an elder law lawyer, do not assume that you're going to get paid from the ward's money. If you are not representing the ward, be mindful of that. And I think our guardianship judges, our judges in the probate division who handle these guardianship matters, do an excellent job of bending over backwards to protect the ward, to protect the alleged incapacitated person, and really trying to protect their money as well. Duties of guardians. You see your Florida statute reference there. You can look at 744.361 in the Florida Guardianship Code. We could talk all about the powers and duties of the guardian, but it's right there for you in black and white. We're not going to spend more time on that. Let's talk briefly about the rules regulating the Florida bar, and then we're going to get into verified statements and then Searle v. Bent, and we'll conclude. Why are we concerned about rules regulating the Florida bar? Because our conduct is governed by that. And because in the guardianship context, as we see in Saadeh, at least in the 4th district, right, if you represent a guardian, you represent, or you have a duty to the ward, right? So be mindful of that. You need to be competent. You need to inform the client of the status of representation. You need to be prompt. You need to be reasonable. You've got to keep things confidentiality. You need to keep things confidential. You have a duty of confidentiality. You should avoid conflicts of interest. And recognize that your fees, if you represent the guardian, are going to be reviewed for reasonableness by the probate court. Also recognize that if you don't represent the guardian, you may not get fees, probably won't get fees, right? If you're a family member who's participating, you're probably going to pay your own way, right? Arguably, if you're the trustee or an attorney in fact, you can be compensated for your time. And certainly if you're the attorney for the ward, for the client, the alleged incapacitated person, you're going to get paid from the ward's funds, but that's going to be reasonable at all times. Okay, verified statements, that thing which is causing heartburn for some probate litigators and those who are involved in guardianship matters. So the question that really created this live CLE for Florida guardianship lawyers is, can a person who files a verified statement bring the wheels of a Florida guardianship to a halt? And the answer is it can. And it can certainly bring a halt to the ward's estate plan. And when I first read the Searle v. Bent case, I was concerned that this section of the Florida Guardianship Code could be abused, right? 744.331, 6, F as in Frank. I was concerned that this could be used, misused, that people will be filing verified statements all the time under the following circumstances. There is a person, an alleged incapacitated person, who can't exercise all of his or her rights. They need some assistance, they need some protection, but there's a power of attorney. Or there's a Florida trust, a revocable trust, a living trust. But the petitioner, the person who's filing this guardianship matter, is not the POA and is not the trustee. Or there's a party to a guardianship proceeding, and one of the parties is not the POA, they're not the attorney in fact, and they're not the trustee, and they don't like the person under the documents who was appointed as trustee of the ward's living trust, the ward's revocable trust, and who the ward chose under that document as the power of attorney. So what do? You file a verified statement, and you say, I have reason to believe that the trust or the amendment or the restatement or the durable power of attorney is invalid. And that causes heartburn for some probate litigators, and that can cause a slowdown in the process and a lot of litigation under the Florida probate code. Verified statements have the ability to be misused, and it's going to be a challenge for litigators as well as guardianship court judges, probate division judges, to determine whether a verified statement is made in good faith or not, because there is a good faith belief that's required, right? If we look at subsection 6F as in Frank of Florida Guardianship Code 744.331, we see two interesting points, right? First, it permits an interested person, and we'll discuss that in a minute, to file a verified statement that he or she has a, one, good faith belief that the alleged incapacitated person's power or power of attorney or trust is invalid. And there's a second part to this. There's a reasonable factual basis for that belief, two-part test. So it's really three parts, right? First, you have to be an interested person. Then you have to have a good faith belief that the trust or the power of attorney is invalid. And you also need a factual basis for that belief. And as any litigator will tell you, you know, there's an attorney's fee, there's a sanction provision in Florida law called 57.105. 57.105 can serve as a basis for a party to recover fees if the other side is making a claim or a defense or filing a lawsuit that has no basis in fact or law. You give them proper notice to withdraw that, and they don't. And so we have a similar situation here with a verified statement. There's a reasonable factual basis for that belief, for that verified statement. But you have to be an interested person. And an interested person, I think the legal trend here is that, you know, somebody who is interested in the guardianship, that used to be a very, very wide net, right? And if you look at the Hayes case in Florida, that is often cited as kind of the standing case. Who has the legal standing, the legal ability to participate in a Florida guardianship proceeding, right? Who can come in and take a stand, hire a lawyer, and be heard by the court? Well, not just anybody. And that makes sense, right? You need legal standing to participate in any proceeding in Florida, whether it's a contract action, a real estate lawsuit, a personal injury action. I mean, we all agree that a person who's unrelated to your matter, somebody random from the Greyhound bus station or the Tri-Rail station or the Brightline station, just can't walk into a courtroom and start filing papers and making argument, right? You have to have some connection, some nexus to the parties in the proceeding. You need legal standing. And the Hayes case discusses legal standing from a guardianship perspective, and specifically how an interested person is defined or analyzed for guardianship purposes. Because for a guardianship proceeding to participate, you need to be interested. You need to be an interested person. Now compare the Hayes case to the Bivens case, right? The Bivens v. Rogers case, a 2014 case from Florida's 4th District Court of Appeal. It's a guardianship appeal, right? 147 Southern 3rd, 549. And it asked the question, does a son of a ward have standing to challenge a guardian's refusal to do something regarding the ward? In the Bivens case, it was an attempt to move the ward to a different state, right? There was a disagreement between the guardian and the son. The son was not the guardian. There was a disagreement. And the son came in and filed something because the guardian wasn't doing something that the son wanted. And the question that Bivens v. Rogers leaves you with is, one, who has legal standing to participate in a guardianship proceeding, and who has legal standing to challenge a guardian's refusal to do something? So what does that mean for probate litigators? Well, it means when you're drafting proposed orders or a court's making findings of fact, and you don't represent the guardian, or maybe you do, You want to consider whether it's appropriate for the court to make findings of fact of who's interested, who's not interested, who can challenge, who cannot challenge. Maybe, maybe not. So, the other thing we need to know about verified statements is get ready to call your first witness, right? An important point to remember about guardianship hearings is they're trials. You need evidence, okay? Particularly when you're dealing with verified statements, right? Because one of the bases for a verified statement is that, one, the person participating in the guardianship proceeding, making or filing the verified statement, has to be an interested person. Maybe they are, maybe they are not, right? There may be a good opportunity and a very valid reason to challenge someone's legal standing in a guardianship proceeding. You can't come in here and file that verified statement. You can't make this argument. You can't take this legal position. Why? You're not interested. Okay, maybe, maybe not. If you're going to take that position, you need to call your first witness, right? You need to introduce evidence. Why? Because you can ask a judge to make a finding of fact about whether somebody's an interested person or not, and the judge needs competent, substantial evidence to support that finding. Also, with verified statements, you need a finding of good faith, a good faith belief that the alleged incapacitated person's trust amendment, or durable power of attorney is invalid, right? So if you're opposing that verified statement, you want the judge to make a finding of fact to the opposite, that this person did not have a good faith belief, right? That it's mere guesswork, it's speculation, right? So if you filed that verified statement, right, you need to demonstrate a good faith belief for that. So you're going to testify, right? And you're going to either need documents or you're going to need testimony. You're going to need to talk about experiences or interactions with the ward, the alleged incapacitated person, or personal knowledge about their estate plan, their trust, power of attorney, their mental state at the time that those documents were executed, or maybe information concerning the execution and procurement, the procurement and execution of those documents. Any of us who have been handling guardianship litigation for years will tell you when you're in front of a judge and a petition for incapacity has been filed and they're trying to suspend the power of attorney, if you walk in with the original ink signature, stamped copy of the power of attorney, many judges will reinstate the power of attorney right then and there, right? Because they want to recognize the validity of an estate plan and put the burden on the other party. So be mindful of that from a strategic standpoint, right? So with a verified statement, you need a good faith belief, then you need a reasonable factual basis for that belief. The belief that the trust or the amendment of the DPA is invalid for any reason, right? So you get ready, call your first witness, introduce your documents. This is a trial. And you know, when we're talking about guardianship matters, they involve some of the most important things in the law, a person's human rights and civil liberties. And courts take that very, very seriously. And as such, these guardianship hearings, these trials, bend over backwards to protect the constitutional rights of the parties. And that typically means you need to give proper notice to the proper people and be provided an opportunity to be heard. And that often includes the opportunity to introduce evidence, to call witnesses, and to cross-examine witnesses. For a discussion of that and your ability to do that, you can read the Zellman case, 175 Southern 3rd, 871. It's a 2015 4th District Court of Appeal case, Zellman v. Zellman, where it talks all about constitutional rights and who's an interested person, and it mentions the Hayes case. Very, very good case. Also read the Fernandez case, right? The Fernandez case is a 2010 case out of Miami, Florida's 3rd District Court of Appeal, 36 Southern 3rd, 175, right? And both those cases discuss one's constitutional rights and the ability to present evidence in a guardianship proceeding, to examine witnesses and cross-examine witnesses. Really, really, really important. I was in a guardianship proceeding prior to 2010, and I wanted to introduce evidence and examine a witness. The probate court judge prohibited me from doing that, and this is before Zellman came out, before Fernandez came out. I was shocked. I couldn't believe that that was happening. I proffered what the evidence would show, and now we have Zellman and now we have Fernandez to guide probate court judges in guardianship proceedings to recognize that you've got to conduct this as a trial, and those examining committee reports are hearsay. You know, upon a proper objection, it should be sustained, and those documents shouldn't come into evidence unless the parties stipulate to them. Otherwise, you call the examining committee members to testify. Okay, let's round up and conclude the Searle v. Bent case, 137, Southern 3rd, 1028, a 2013 opinion from Florida's 2nd District Court of Appeal. There was a 32-page order issued on rendered on June 8th, 2011, in the matter of Dane F. Searle. Miss Searle was the alleged incapacitated person. Her daughter was Miss Bent. Miss Bent filed the guardianship petition, and the lawyer for Miss Searle, the mom, opposed it. And so the court made a very lengthy ruling in its order on petition to determine capacity and amended findings of fact on hearing to determine incapacity. And this 32-page order was the subject of the appeal in Searle v. Bent from September 18, 2013. So over 2 years from the time that that order on the petition was rendered till they got an appellate court decision. So people ask us, John, how long will an appeal take? In some cases, it can be 6 to 9 months. In this instance, it was 2 years. Why was it so long? It depends on when you file your notice of appeal. It depends on how many extensions of time are granted. You can ask my law partner, Rob Hauser, more about that. Rob is board certified by the Florida Bar in appellate law. He handles all of our appeals at Pinkowski-Hauser. He handles all the guardianship, trust, estate, and probate appeals. He's in every single district court of appeal in the state of Florida right now. In fact, he was in Miami the other week for oral argument, and he just delivered oral argument late last year, 2016, before Florida's Supreme Court. And so, what are 5 takeaways from this Searle v. Bent case? Well, let me give you the background very quickly. As I said, it was a daughter versus mother matter. Ms. Bent was the daughter. She filed the petition to determine the capacity of her mom. And the trial court determined that mom, Miss Searle, Dane Searle, was incapacitated. And Ms. Searle filed an appeal and said, hey, the trial court erred. The error was it didn't consider the less restrictive alternatives to a guardianship. I had an entire estate plan. And sure enough, this guardianship petition was filed in 2010. So it's filed in 10. This ruling is issued sometime in 2011 in June, right? The appeal comes out in 2013. So you can see it was a very long, hotly contested guardianship, and there was a reason for that. There were allegations that Miss Searle was a very wealthy woman. She was incapacitated, it was alleged, due to poor physical and mental health. And there was a concern by the petitioner that mom was being exploited by her caretakers, right? And so a verified statement was filed, and it said that mom's documents, estate plan after December 3rd, 2006 were invalid. Why were those invalid? Why was the estate plan invalid? Because mom lacked the mental capacity to sign those documents, or because the documents were the product of undue influence. Okay. An extensive evidentiary hearing proceeded. There was extensive evidence presented and received, and the verified statement filed by the daughter was considered. And according to the court, it established a reasonable factual basis to believe that mom's trust amendments, and durable power of attorney were invalid and thus not an alternative to a guardianship. So the court had the discretion to look at the evidence, make that finding, right? There was a reasonable factual basis to believe that the verified statement was true. It was accurate, that mom's estate plan was invalid, and therefore there was not an alternative to a guardianship that sufficiently addressed mom's need. That decision by a guardianship court will be upheld, absent abuse of discretion, and what that means is it based on competent substantial evidence. Clearly in this case it was, right? There was a lot of evidence. There were specific findings of fact in the 32-page order. On appeal, Ms. Searle contended, hey, you totally disregarded my estate plan. I had this very detailed estate plan over the years, powers of attorney, trust amendments. You threw it out the window. You brought my estate plan to a screeching halt, all because my daughter filed that verified statement. And the appellate court said, hold on. We agree with the trial court. The trial court said, I'm not rendering an opinion on whether those documents are valid or not. All I'm saying is there's a reasonable factual basis from that verified statement and from the other evidence that the court weighed to believe that those documents may not be valid. I'm not saying they're valid. I'm not saying they're invalid. All I'm saying is there's a reasonable factual basis that they may not be valid. And under the statute, which we have to read with its plain and obvious meaning, right? Go to 744.3316F2, under those circumstances, where there's a reasonable factual basis for the belief that those documents are not valid, that there is not an alternative to a guardianship that sufficiently addresses the needs of the ward, under those circumstances, those documents, that estate plan, shall not be deemed to be an alternative to the appointment of a guardian. So the trial court, the guardianship court, the probate division considered those documents, but it considered a lot more evidence, and it considered the verified statement. So there was nothing in the order, there was nothing in the statute that said those documents are invalid. They may or they may not be. And the appellate court also noted that, look, if you think that a guardianship is or is not needed at a later time, nothing prohibits you under the Florida guardianship laws from going back in and asking the court to review everything again and to relieve the parties of the guardianship. What are 5 takeaways from Searle v. Bent? 1, is there a reasonable factual basis for the verified statement? Is there a reasonable factual basis to believe that a certain estate plan, power of attorney, trust amendment, restatement documents are invalid? 2, prepare your evidence. You need testimony, medical records. Maybe you get them, maybe you don't. We know that mental state does matter. We can argue about whether a non-party, or I should say a non-client, can get the medical records of somebody or not, or whether HIPAA or other privacy concerns prohibit you from getting those. What are the eyewitness accounts? What are the other documents? What's your evidence to demonstrate that those documents might not be valid? 3, ask yourself, whatever findings of fact I'm asking a judge to make, are they supported by competent substantial evidence? 4, good faith belief. How was that developed? When was that developed, and by what means, right? If I'm challenging a verified statement in a Florida guardianship proceeding, I'm going to ask you all those questions, and I'm probably going to ask you in a deposition before I call you to the stand. I may or may not save some of those questions for trial, but I want to examine that good faith belief with a microscope. And by the same token, if you are filing the verified statement, you got to ask yourself, what's your competent substantial evidence? What's the basis for your good faith belief that those documents, that estate plan, are invalid or is invalid? And then finally, prepare for an appeal, right? My law partner, Rob Hauser, is board certified by the Florida Bar in appellate work. He handles guardianship appeals. He most recently had one in 2015 in Florida's 4th District Court of Appeal, for which he was honored. Be mindful of the appeal, whether you win or whether you lose, but be also mindful of what the other side may do, right? And there's certain things that you need to do at the trial level to prepare for an appeal. And sometimes, you know, probate lawyers in Florida only think of appealing if you lose. Well, you may win and the other side wants to take an appeal. So you need to make sure your record's clear. You need a court reporter. There's a number of other things that you want to do in anticipation of a possible appeal. At the end of the day, you're trying to do everything you can to protect your client, look out for them, advocate as hard as you can, and get the record as crystal clear as you can. Because at the end of the day, in a guardianship matter in Florida, it's everybody's job, even though we're advocates for our clients, to try to get this right. My name is John Pinkowski. This concludes my remarks about verified statements, the Searle v. Bent case, and Florida Guardianship Code 744.331. There is 1 hour of CLE credit available for this from the Florida Bar. It's on the slide in front of you now. The reference number is 1609-637, N as in Nancy. My name is John Pinkowski. I'm managing partner with Pinkowski Hauser in West Palm Beach. If we can ever be of assistance, please give us a call or email amanda@phflorida.com. This now concludes this live Florida Bar approved CLE. Thank you for listening.